right now?
It's in the. Let me see.
Facebook group.
And how do I get there? Like, I'm just really new. This is my first time with everything, so I'm not understanding anything.
It's okay. All right. You got the numbers through the Facebook group, correct?
No.
Okay. How were you? How did you get the call information?
When I signed up. Oh, did I get it from your Facebook? I know I liked your Facebook page. Maybe I did get it from there. Oh gosh. All right, let me go in there. I'm sorry.
It's a little group on the Facebook.
Okay.
Okay. So what? You go to Facebook.com and search financial ID members only, and the group should pop up. If you're in the group, that's how you should have got this number.
Okay, I'm there.
Okay. And the link is on the page. Click on the link, and it will prompt you to download the program called Any Meeting. Okay.
Oh yeah, I see. Okay.
All right. Check it out and try to jump back in. Hold on one second.
Appreciate it. Thank you.
No problem. No, all right, guys. So this is called Presumption of Death. All right. The first term we want to go over tonight is called civilly dead. We've covered this term before. Okay. It's and I'll read it real quick here. Civil death. Civil death. Write that down. All right. Civil death. In Latin, civiliter mortuus, is the loss of all or almost all civil rights by a person due to a conviction for a felony or due to an act by the government of a country that results in the loss of civil rights. Most people are, we're not talking about just the civil rights movement, okay? We're talking about this period, natural man's rights, okay? Period. All right? Well, you may have lost these rights by the act of a government. That's right off Wikipedia, guys. Okay? And you can continue to search this term even through other. Let's go to a legal dictionary. Let's talk about it. Okay? Civil death, the forfeiture of rights and privileges of an individual who has been convicted of a serious crime. So, people with felonies. Okay? Civil death is provided for by statute in some states. Most civil death statutes apply only to offenders who have been sentenced to a life term. Civil death involves the imposition of numerous disabilities, including the denial of the privilege to vote, to hold public office, and to obtain many jobs and occupational licenses. In addition, an offender cannot enter into judicial enforceable agreements, such as contracts, and may not obtain insurance and pension benefits. The offender may also be deprived of any right to commence certain lawsuits in court. Successive marriages can also be affected by civil death laws. Okay? The issue is whether or not the spouse of a person declared civil death may enter into a subsequent marriage. The state courts are in disagreement on the matter. Okay? Civil rights. Now, this law definition, it actually gives you more of the just if you got convicted side of it. So Wikipedia actually brings it all the way out this time. Act by the government. Okay. I have a document. This is actually Mercer Beasley Law Review from January 1936. Okay? And it's volume number 1, and it's Presumption of Death in New Jersey. All right? What is the presumption of death? Who would like to volunteer for me and read, please? You know, we got just a few people on here that have strings. Randall, you there? Can you see? All right, I'm going to take off. Presumption of death in New Jersey. Every person must, at some time in this mundane existence in death. After death, a person's estate becomes susceptible to distribution, either by virtue of the terms of that person's last will and testament. All right, go ahead, Ram. Last will and testament, I finished the sentence. Of or by virtue of our statutes relating to descent and distribution.
The surviving spouse of one who dies is relieved of the bonds of matrimony and is free to marry again. The legal effect of death thus becomes one of the important phases of the administration of law and of orderly procedure in social affairs. Where death occurs as an actual probable fact, the legal incidents of death attach at once, and no serious legal questions arise other than perhaps those relating to interpretation of wills or to determination of the persons taking the estate of a dead person according to our laws and statutes pertaining to descent and distribution.
Okay, so now notice if you don't have a will or estate or anything like that, it automatically goes to their statutes. So it's very important you guys do start reading over and start understanding your last will and testament. It's a very important thing that every person should do. Okay? Go ahead.
There are, however, many instances in which death is not a probable fact. One may go on a journey and never return. A man may suddenly disappear from his old haunts, and his relatives and friends may never again see or hear from him. A man may be a fugitive from justice, or may have had serious domestic difficulties, or may have brought upon himself some actual or impending disgrace, or may have become hopelessly indebted to others. Because of one of these situations or any other making him desire to avoid contact with others, a man may mysteriously and completely disappear, never again to appear or to be heard from. But at some time in his life, death must come to him. The first presumption is, of course, that a person once alive continues to live until the fact of death is proved or until the presumption is overcome by a contrary presumption. At early civil and canon law, it was presumed that a person would be alive until he might have attained the age of 100 years. Under this presumption, one who disappeared might have many years of presumed life before death might be presumed. This resulted in such a ridiculous legal and social predicament that the common law early altered this presumption to the end that a person would be presumed alive until the contrary presumption arises, and then fixed the period for presumption of life at 7 years after disappearance.
All right, hold on. That's a very, very important line, guys. It's 7 years after disappearance. Okay. Now, so a long time ago, if you just disappeared one day, they assume that you was at they at least give you till you was 100. Okay, 100, and it just became daunting trying to keep track. Is that person 100 now? Okay. So now, after 7 years of being disappeared, you're presumed to be dead. All right, pay attention now. You're presumed to be dead if you disappear for 7 years. Go ahead.
At the conclusion of such a 7-year period, the presumption of death arose. This at first was considered a presumption of fact, but our courts now regard it as a presumption of law. If at any time after the 7-year period the person presumed to be dead reappears or is heard from or is proved to be alive, the presumption of death is, of course, rebutted.
Whoa. So even if you did show up like 8, 12, 24 years, 30, 50 years later, and you showed it, read that one more time, the highlighted portion. Read that one more time.
If at any time after the 7-year period the person presumed to be dead reappears or is heard from or is proved to be alive, the presumption of death is, of course, rebutted.
So doesn't your affidavit on your authenticated birth certificate sound like proof that you're still alive? It sounds reminiscent to Minnesota Rule 220. You consider a martyr until you have an authenticated birth certificate with an affidavit on it, okay, stating that you one of the parties said in there. I'm gonna prove it. I promise you, because they're playing a very tricky game. All right. When a boat, does anybody know about maritime commerce? Do you have anybody in the group know anything about international shipping? Okay. Because when you're dealing with international shipping, you got boats that land and dock on land. It's called maritime. It's called admiralty law or maritime law. All right? These boats dock. They're born into the country that it's in. Okay? And on the contents of the ship is now in the jurisdiction of that country. And they have to give it a birth, BERTH, certificate for all the items that's on the ship. Okay? Our governments all over the world have established where through the birth certificate we're considered that we've disappeared into the state. I'm going to say that again. With the birth certificate, your mom birthed you out of her waters, okay, through her canal, into the state of Georgia, Alabama, the city of New York. Okay? Your mom filled out a birth certificate for what came out. That certificate was given to the state. You had been born into the state of or the city of. After 7 years, you were presumed dead. Okay? Go ahead. This is common law presumption of death.
This common law presumption of death has now become fixed by statute in most, if not all, of the states of the United States. Our first New Jersey statute relating to the subject was enacted in 1797.
Get it right now.
Our first New Jersey statute relating to the subject was enacted in 1797. It was declarative of the common law at that time, and is commonly known as the Death Act. It provided as follows.
Section 1, Death Act. Let's go.
It provided as follows. Section 1. Any person who shall remain beyond sea, or absent himself or herself from this state, or conceal himself or herself in this state for 7 years successfully, shall be presumed to be dead. In any case where in his or her death shall come in question, unless proof be made that he or she were alive within that time. But in a state recovered in any such case, if in a subsequent action or suit the person so presumed to be dead shall be proved to be living, shall be restored to him or her who shall have been evicted, and he or she may also demand and recover the rents and profits of the estate during such time as he or she shall have been deprived thereof with cost of suit.
With cost of suit. I love that part. It's just like, man, you talking about dying, and then it's like, but if you came back, but you came back. All right, the Death Act, Section 1. Go ahead, let's read. Anybody have any questions right now? I haven't read this in so long. Man, I had this years ago. I mean, since I started reading, and I found it and just started reading it. I wasn't even ready for this when I read this the first time. But anyway, I understood what I was reading though. But this is beautiful. I know if any of you all have heard, my grandmother passed last week. I appreciate all of you all's support and blessings and prayers. I appreciate it. My family appreciates it. And we're having to get some people off of some land that my grandmama had a deed from 1949 that I found at her house. Okay. And knowing that I'm going to have to go through probate court and go recover it for my family. Okay. So what we'll read right now, I help you claim your estate. You have an estate. You were presumed dead because you were. I'm going to slide back up real quick. Randall, touch this point right here. Right, read section 1 more time. Listen to it. And go slow at the commas.
Any person who shall remain beyond sea.
And beyond sea. So beyond sea, the lost at state and lost at sea are the same thing. Okay? Lost at state. Listen how they word the next part.
Or absent himself or herself from this state, or conceal himself or herself in this state.
Conceal himself or herself in this state. So what if you was concealed in the state without your permission? You didn't really have a choice. You woke up one day and you just got concealed in the state through a birth certificate. You didn't even sign the thing. Okay? Go ahead.
For 7 years successfully shall be presumed to be dead in any case wherein his or her death shall come in question, unless proof be made that he or she were alive within that time. But in a state recovered in any such case, if in a subsequent action or suit the person so presumed to be dead shall be proved to be living, shall be restored to him or her who shall have been evicted. And he or she may also demand and recover the rents and profits of the estate during such time as he or she shall have been deprived thereof with cost of suit.
With cost of suit. So let's jump over here. We go back to the same rules a lot. Okay? But when you're able to read them and cross-reference, and this type of reading and cross-referencing like this is a very biblical principle. Okay? Line upon line. Precept for precept. So let's read this birth certificate thing and compare it. Now this is, this new, this real internet right here. Like this new stuff right here we're reading, right? Okay. All right, that's the
Yeah.
rules of general rule, right? And then we over here dealing with this 1936, right after the whole country went bankrupt. Okay, they don't teach this information right here in law schools anymore. So I apologize for the summa cum laude judges and stuff like that graduated top of their class and they don't know what happened. Okay, because they don't teach it in law school anymore. Go ahead. This act remained in effect until
1895, when the legislature amended it by enlarging its provisions to apply to any person, whether a resident of this state or not, who shall remain beyond sea, absent himself or herself from this state or from the place of his or her last known residence, or conceal himself or herself in the state or in the place of his or her last known residence for 7 years successfully. It further provided that if an executor or administrator should pay over any legacy or distributive share of an estate to which the presumed dead person would have been entitled, he or she shall be fully discharged of any liability therefore upon filing with the surrogate of the proper county releases and refunding bonds of the persons entitled to take if the presumed dead person were actually dead.
the refunding bond. See, guys, y'all helping me study right now. I'm going to need some refunding bonds on what we found the other day from the probate court. All right, go ahead. Let's see, 1911.
In 1911, the legislature passed a supplement to the Death Act, which supplement first provided for a decree declaring a person to be dead. This statute limited its provisions to a person being a resident of this state who shall
A resident of the state. So now you see, now just being a resident of the state makes you considered to be considered civilly dead. Go ahead.
Who shall remain being a resident of this state, who shall remain beyond the seas, absent himself or conceal himself for 7 years successfully. It further provided that the ordinary or the surrogate of the county in which the person had resided at the time of disappearance shall, upon application by any next of kin of such person, make an order to show cause. Wait a minute. I got kicked off. Pick up for me.
All right. An order to show cause returnable at a definite place and time, no less than 30 days or more than 3 months from the date of the order, why a decree should not be made declaring said person to be dead, or if there be personal property belonging to such person, why letters of administration should not be granted. Such order shall be published in such a manner as the ordinary or surrogate may direct, and if it be proven to the satisfaction of the ordinary or surrogate that such person has remained beyond the sea, or absent himself from the state, or conceal himself within the state for 7 years, then last passed successively, or has not been heard of or from said period. I'm going to slow down real quick for you guys real quick, all right? I want y'all to pick up something to show you how you read law. You'll notice that they keep saying or to make sure they all the way describe what it is they're saying. That's why it may seem like it's cluttering on you. But if you pay attention to those ors, it's a continuation. It continues the statement, and it further. That's all legal writing is. It's trying to. It's a form of coding, but it also expresses clearly what is being conveyed. Well, it expresses it in a legal sense. Okay. The ordinary or the surrogate may make a decree declaring the said person to be dead, or may grant letters of administration upon the filing of the usual bond of an administrator. In 1926, the legislature amended the supplement of 1911 by inserting in the act that the application to the ordinary or surrogate might be made by the husband, wife, or next of kin of such person, instead of next of kin, alone, as in the 1911 Act, that administrative right might be granted to the husband, wife, next of kin making the application, or to someone who fit and proper person. In 1927, the legislature passed another supplement to the Death Act, which is similar to the acts of 1911 and 1926, except that it provides that the application to the ordinary or the surrogate for the order to show cause may be made by any next kin, creditor, bet y'all didn't know who's going to hear that word, executor, administrator, or any beneficiary or beneficiaries under a policy of life insurance, and that the letter of administration may be granted to the next of kin making the application, or unmuted. Okay, or to such fit and proper person as the said ordinary or surrogate may deem advisable. It will be noted that the Death Act of 1797 and 1895 provides that the person who has disappeared shall be presumed to be dead, and that its terms apply to any person, whether a resident or not, and further provides for the restoration of his estate to the person presumed dead if he returns alive. The supplement of the Death Acts 1911, 1926, and 1927 provide for a decree declaring the said person to be dead. Designate the class of persons who make applications for the order to show cause for such decree, and provide for granting of administration of personal property of the person so declared to be dead. Here's the mean curveball, guys. I hope y'all still following me. The Orphans Court Act. If you all have looked up the Hague Convention, you watch this. And I just found this out the other day. Okay? Hague. I knew I didn't want to be in the Hague Convention, but I actually read it, and the Hague Convention is the Hague Convention of the Protection of Children and Cooperation in Respect of Any Country Adoption. Hague Adoption Convention is an international agreement to establish safeguards to ensure that inter-country adoptions take place in the best interest of the child. All right? Now, sounds good, don't it? Right? People, you got a uniform system so the child can be adopted, right? What if you was being traded and adopted on a daily basis by like China or something, you know? Like, you wouldn't want your new stepdad and them to show up. All right? This is a benefit of having authenticated birth certificate, okay? You don't want to be adopted. I promise you. And now if anybody's been adopted, I apologize. I'm not trying to offend any. But being adopted, you hear about the stories of people who have. Some people inherited money being adopted. Some people went through bad things being adopted. Okay, but in this case, being adopted is not what you want. Now, that's the Hague Convention. Now, when they ask you, when you want to authenticate your birth certificate, and they ask you for what country, they're going to specifically ask you, are you getting authenticated for a country outside the Hague Convention or inside the Hague Convention? Okay? They'll ask you, inside the Hague Convention or outside the Hague Convention? Okay? Jamaica's outside the Hague Convention. Most of Africa is outside of the Hague Convention. Okay? All right? So now let's look real quick. You got the Hague, and then you got what we call an apostille. I'm going to show y'all something. Write this word down, apostille. An apostille is a form of authentication issued to documents for use in countries that participate in the Hague Convention of 1961. A list of countries that accept apostilles is provided by the U.S. State Department. Let's get apostille. See where it goes to. All right. Hold on. One second. Apostille, additional authentication required for international acceptance of notarized documents, including but not limited to adoption papers, affidavits, birth certificates, contracts, death certificates, deeds, diplomas and decrees, divorce decrees, incorporation papers, marriage certificates, patent applications, power of attorney, and school transcripts. Instituted by the Hague Convention, abolishing the requirements of legalization for foreign public documents of 1961. Its objective is obviate the requirements of diplomatic or consular legalization and thus replace the cumbersome chain authentication method that call for verification by multiple authorities. So an apostille is actually the exact opposite of authenticating. This is what we want to do. We're doing a chain authentication method. Okay? The apostille gets rid of it. Okay, you don't need a chain authentication. Just apostille it. We don't have to. Now, I can't call off the top of my mind right now where I read that the apostille just certifies the documents. I'm gonna find that for you, and I post it up in the group for 2.0. All right. Now, we want to get authentication. Definition. Authentication. Authentication is any process by which a system, no, not the right one. Let's get the law definition. Lots of authentication. Authentication in the law of evidence is the process by which a documentary evidence and other physical evidence is proven to be genuine and not a forgery. All right? So the apostille is slightly different, and it keeps you inside the Hague, and it keeps you adopted. All right? The Orphan Act, Court Act. Go ahead, Randall.
All right. The Orphans Court Act, as enacted in 1898, contains 3 sections relating to the estates of persons presumed to be dead. Section 30 relates to any person being a resident of this state who remains beyond the seas, absent himself from the state, or concealing himself within the state for 7 years successfully, and provides for the granting of letters of administration to the next of kin. This section was amended in 1926 to provide that letters might be issued to the husband, wife, or next of kin making the application, or to such fit or proper person as the ordinary or surrogate shall deem advisable. This section is very similar in its wording to the supplements of 1911, 1926, and 1927 of the Death Act, except that it does not provide for the making of a decree declaring such disappeared person to be dead. Section 31 relates to a person not a resident of not a resident of New Jersey, but having goods, chattels, monies, and effects in this state, who shall absent himself or herself from the place of his or her domicile for 7 years successfully. It does not provide for a decree declaring such person to be dead, but it permits the ordinary or surrogate to grant letters of administration to the next of kin making application. Therefore, if the proof is satisfactory that such person has an absolute...
Stop. Here we go, right here. Go back again. Go back to permits the ordinary or surrogate to grant, to grant letters of administration to the next of kin, making application therefore of, if proof is satisfactory. Now listen very closely. When you walk into a courtroom, you are presumed and assumed dead and lost at sea or lost at state. Now you're lost. So guess what? The next of kin, according to what we just read, can be anybody. And that anybody is the prosecutor. That anybody is the judge. That court. Okay? They're administrating letters to an estate of someone who's assumed dead. And they're making you the trustee of it. Okay? It's all estate. It's applications for estates. Administrating of estates. All right? And we went extensively over, y'all go back and look at some of the law texts, we went extensively over types of estates. Okay? A lease is a type of estate. So you already have been administrators to estates. You've just been on the renter side of it. The renter is the tenant. And the tenant's at the bottom of the totem pole, and the tenant has to pay the overhead to be able to sit there and maintain it for the overlord. And then the person who overlord is probably the homeowner or the property management, and then they got the real owner, and then the next owner is the state, and so forth and so on. Okay? Now, you yourself are in an estate, and it's an ecclesiastical estate. It's an estate associated with the highest estates on the planet, your soul. All right, go ahead, guys. They want this. They want to administer to your estate. Okay, go ahead. They make money. That's how they eat, off of you. Satisfactory that such person has absent himself
My bad.
It's satisfactory. It's satisfactory. You got it?
Okay. It's satisfactory that such person has absented himself or herself from the place of his or her domicile for 7 years, then passed successfully. This section was also amended in 1926 so as to permit the application to be made by and letters granted to the husband, wife, or next of kin. Section 32 provides that any administrator appointed under the two preceding sections shall administer the estate as if the presumed dead person had died intestate, and after payment of debts, etc., shall make distribution to those persons entitled by law to receive the estate upon his or her or their giving to the administrator a bond or bonds with good and sufficient sureties upon condition to refund and pay back to the administrator the share received by them, respectively, with the accumulations thereof, if the person presumed to be dead shall, at any time after, reappear. Scroll down. Reappear and claim the same, which blood or bond shall be full protection to the administrator if such person does reappear and claim the estate after distribution made thereof, and that such administrator shall assign such bond or bonds to the person so reappearing and claiming the estate, after which the administrator shall not be liable for any act done by him under and by virtue of his office as administrator.
Mm-hmm. So every time an estate is created, they create an office of administrator. Okay, and they administer the estate. Now, dealing with this term, you're talking about basically, it almost sounds like computer systems. An estate. Now they've drawn up these documents say this person's dead and everything that's associated with you. They're calculating it up and selling it or maintaining it for the benefit of whoever your next of kin. So they sit there and administer to it. Now you got all these estates running around here, lost that state. All right, your municipal courts and things of this nature are all feeding off of that. Oh, look, caught you speeding. I caught an estate. Get over here. Pay. Don't get out of jail until you pay $300. Because they're making you the tenant or the trustee to the estate, putting you at the low end of the totem pole. Saying, okay, they're taking hold of your estate and making you the trustee to take the brunt of everything, the fees, the fines, and they don't even say their name for the record. Okay? Go ahead.
The presumption of death does not arise where the supposed decedent has been heard from or there is reliable information that he was alive within 7 years. The primary burden is, of course, on the person asserting that the absent person has not been seen or heard from for 7 years. Then last
pass successively to produce evidence to sustain that assertion before the presumption of death will arise. This evidence must disclose that he has been absent from his last known resident for the prescribed period and that all available sources of information as to his whereabouts have been exhausted. Ordinarily, the evidence given by his family, relatives, friends, now listen to that, the evidence given by his family, relatives, and friends, okay, and former associates together with inquiries made by them will satisfy this requirement as to evidence. Now, Think about it. Your mom is your family, and she and sometimes your dad signed the evidence of you going into the state. You being adopted by the state. They're not telling you that you're being adopted by the state when you do that. That's why you got public assistance, public housing. You're public. It just is what it is. Now, I would say if you got some public housing, stack your bread up and stop playing. All right? Real talk. Stack some money up. Go ahead, Randall. We're going to close out on this page.
Still not back in.
Oh, gotcha. The presumption of death does not arise when the supposed decedent has been heard from or there is reliable information that he was alive within the 7 years. The primary burden is, of course, on the person asserting that the absent person has not been seen. So now, when you're drawn and your estate is drawn into court, and they're trying to administer to that estate, when you show them that you are in control of your estate and you not lost, it shuts them down. They done. Okay? They can't do anything because they don't have any jurisdiction over that the entity that they're trying to draw energy from. And I'm serious, because when you get a $200 ticket and you got to go pay $200 again or $377, yeah, you still gotta go do some work to pay that back. So that's your energy. All right. The primary burden is, of course, on the person asserting that. So when you come in with an affidavit on an authenticated birth certificate, they're gonna have real trouble saying that they can administer to that state. Okay, this evidence must disclose that he has been absent from his last known residence for the prescribed period, and that all available sources of information as to his whereabouts have been exhausted. Ordinarily, the evidence given by his family, relatives, friends, and former associates, together with inquiry by them, will satisfy this requirement as to evidence. But if a person absenting himself has not been heard from in 7 years, last passed successfully, the presumption of death arises at the end of that period, and a person seeking to rebut that presumption must show that the person was alive or heard from within the 7-year period. The burden of proof is upon the person asserting a continuance of life. Thus, the case of Holt versus Newbold was brought to recover possession of an undivided 1/7 of a lot of land. The land had been owned by Tours, who had 7 children and had died intestate. One of his children left home in 1852 to go to California and was never seen or heard from thereafter. By partition suit, this son's interest in the land was set off to his children. 22 years after his son's disappearance, the plaintiff produced a deed signed by a person of the same name as the son who had disappeared. The court held that the burden was on the plaintiff to prove that this son was still alive and said, the mere fact that the deed was signed in California in 1874 by a person named Abraham A. Tours, or using that name, does not prove that such person was the son of Abraham A. Tours Sr., or that he was the living, or that he signed the deed. There should be something more than similarity of name to overcome the presumption of death raised by the statute. The court further stated that it would be necessary to prove the identity of the one signing the deed, either by evidence of those who knew him or evidence giving a definite description of him or at least proof of his handwriting. In some states, the presence of a motive for disappearance has some effect upon the presumption of death after 7 years' absence. In New Jersey, our statutes make no reference to motive for disappearance. It would therefore seem that the only necessary proof is that the resident of the state has remained beyond the sea or absented himself from the state or concealed himself within the state for 7 years, then last passed successfully. The fact that he is a fugitive from justice or had family or domestic difficulties or has fled from the stigma of some disgrace has no effect upon the presumption of death if he has disappeared and not been heard from for the statutory period of 7 years. Our statute reads that there shall be a presumption of death where a person, a resident of this state, shall remain beyond the sea or absent himself or herself from this state or conceal himself or herself in this state for 7 years successively. The disjunctive wording of this statute was discussed in the case of Osborne versus Allen, where it was claimed that the statute had altered the common law rule and made it necessary to prove one of the alternatives specified in the statute. Chief Justice Green comments on the arguments as follows. It is obvious that this construction of the statute would totally defeat its objective. Evidence that the party was actually absenting himself from the state or was concealing himself within the state. Now, the thing is, you got to have evidence that the party actually did this. You didn't do anything, guys. You were just born. Okay? You can see why you would want to have rules like these. You don't want, what do you do with the people's stuff? We're so used to, we got cell phones and all that good stuff. So you usually don't, Facebook, something, Instagram, text message. People stay in contact now. But back in the day, if you just said, hey, I'm going to California and you don't show up 3, 4, 5 years later, you know what I'm saying? That's a long trip without a car or a plane. Okay? So what are you going to do with this land right here? Okay? That's how land and ownership is transferred. Estates and probate. Anywho, guys, I hope I wasn't too downer for you since we're talking about death so much. But I really love those parts when they say coming back to life. Minnesota Rule 220 birth certificates. The Register of Titles is authorized to receive for registration of memorials upon any outstanding certificate of title of an official birth certificate pertaining to a registered owner named in said certificate of the title, showing that the date of birth of said registered owner, providing there is attached to said birth certificate an affidavit of an affiant who states that he/she is familiar with the facts recited, stating that the party named in said birth certificate is the same party as one of the owners named in said certificate of title, and that thereafter the Register of Titles shall treat said registered owner as having attained the age of majority at a date of 18 years after the date of birth shown by said certificate. Now, did anybody tell you that you're considered a minor until you do all that? Well, that means you're probably adopted in the Hague Convention, and you might be civilly dead. All right. Guys, I really appreciate you all. I'm going to open up for any questions, comments. Class Sunday, we will be going over your credit, getting rid of those debt collectors. If we wasn't reading all this stuff over here in the background, we wouldn't know how to, get checks back from debt collectors, make debt collectors pay you. All right? Hey man, I'm glad I picked this up. I didn't, I'm gonna read some more in there. Appreciate it. Thank you guys. So I see you all soon. We'll be planning upcoming events. We'll be traveling more. All right. So just keep your ears tuned. We will be getting out. Invite friends and families to enjoy the benefits of our program. And y'all have a great evening, guys. Talk to you later. Hey, look, don't